Welcome everyone, and thank you for joining us for the March edition of the 2017 Educational Webinar Series. My name is Lori and I will be your moderator today. Today's webinar is titled It's the Law. We'll be talking about legislative changes, liability issues, and how to protect your business in relation to food allergies. We have a wonderful guest presenter, Mr. Ryan Gambala, who I will introduce to you here shortly. But first, before we get started, I want to go ahead and take you through a couple of housekeeping items. We will be muting all of you during today's webinar, so you won't have to worry about the background noise wherever you are tuning in from. Second, on your screen you'll see a small chat box. Please use the chat box to type in any questions you have as we go through the slides today, and at the end of the webinar we will answer as many questions as possible. We should have a good amount of time for questions, so please don't be shy. Type in those questions as they come. I want to mention that we do have a record number of participants pre-registered for today's webinar. So there is often technology issues that come along with that. If for any reason the audio goes out on our end during today's webinar, just stay on the line and you will be placed into a lobby and be reconnected once we get the audio back up. If you happen to lose the connection on your end, just dial back in and you'll be placed right back into the webinar. And finally, we will be recording the webinar today. The presentation will be published on the MenuTrinfo YouTube channel for later viewing and sharing. So if you're having issues connecting, please remember that. You can view it later and also share with your colleagues. However, I do encourage you to still take notes and ask questions to make sure you can take back all of this information to your brand. And there will be a link provided in the email you receive after today's webinar with the post on YouTube. Today's webinar is sponsored by Allergy by MenuTrinfo. Due diligence for food allergies is the name of the game, and Allergy is the answer. Allergy is designed with a restaurant's busy schedule in mind to give a valuable review on important food safety topics. Allergy can be utilized at any all-staff or pre-shift meeting to review topics on food allergies, gluten-free, and emergency protocols. A subscription to Allergy includes a new poster every month, step-by-step training instructions, a training outline, and an employee sign-off sheet. Call 888-767-6368 to sign up or request a free sample. Allergy is a simple, easy, convenient, low-cost solution for ongoing food allergy training. So with all the housekeeping tasks behind us, I'd like to go ahead and dive into the webinar. Our guest presenter today is Ryan Gambala. Ryan Gambala chairs the Food and Beverage Industry Practice Group at the law firm of O'Toole, McLaughlin, Dooley, and Pecora in Cleveland, Ohio. Mr. Gambala has been an industry leader in understanding the requirements, nuance, and consequences of the Food Safety Modernization Act and the corresponding federal regulations. His work includes regulatory compliance and consulting, federal investigation, and audit response and litigation. His clients, which range from Fortune 100 companies to closely held family businesses, include food dealers and wholesalers, restaurants and hospitality businesses, and transportation companies. In addition to his legal work, he is a speaker and regular author on food safety, legal compliance, and liability for food and beverage companies and executives. So with that, I'd like to hand it over to Ryan.
Thank you very much for that introduction, Lori. I appreciate it. Like Lori said, ladies and gentlemen, I'm Ryan Gambala. I'm a partner with the firm of O'Toole, McLaughlin, Dooley, and Pecora in Cleveland, and I chair the Food and Beverage Industry Practice Group. I'm going to talk with you today about our presentation called It's the Law, Knowing Current Food Allergy Legislation. I do, as Lori suggested in her opening remarks, I would encourage you to submit questions. We're going to save some time at the end. It's not, when I give this presentation live, it's a little bit easier to take questions as we go and kind of work in hypotheticals and examples as we go through the steps, but please do submit your questions. I am going to reserve some time at the end to address some of those. Also, if you have specific questions that you want to ask in private, my contact information will be available at the end and I would welcome inquiries from any attendee of today's webinar. I'd be happy to try and point you in the right direction if I can, or if we run out of time. Before we get started today, I do have one kind of housekeeping item of my own. It's a disclaimer because, while some of this may seem obvious, as lawyers we take things that are obvious and make them complicated. Just so everybody attending today's webinar is aware, this is for informational purposes only. This webinar does not create an attorney-client relationship. This is not legal advice. I'm going to review some of the laws that would be applicable to the food industry, specifically as it relates to allergens, but this is not a comprehensive review of all laws. So with that out of the way, I want to get in to the meat of today's presentation, and we're going to start, if I can, with update on some food allergy legislation, some things that are going on in the states here. And what we'll do is we'll talk a little bit about some of these legislative updates, and then we're going to, the focus of the presentation is going to be a little bit more practical in terms of food allergy situations or legal issues that you might face at your restaurant or university, and how to put yourself in the best position to deal with those. But at the outset, I think it's important to note some of these legislative updates. I've got two slides on this. And really this first one I think is the most important. You can see what's going on in Maryland here in another couple of months and what's already going on in Michigan. And we're talking in a very general sense in those states about statutory requirements for at least one person on premises all times that has qualified training on food allergens, allergen awareness, what to do if somebody's having an allergic reaction, et cetera. And I know some of our sponsors here today provide that kind of training, but I will tell you that these states are leaders in this regard. This is the direction that the rest of the states are going to be going. As some of you know, maybe if you work for a state university or a federal or state department, sometimes the statutory and regulatory process can be time consuming and kind of slow to adapt to what's going on the ground between rulemaking and law drafting and comment periods in votes and all the rest of it. But this is the direction that the legislature is going. And so what we're going to be talking about today is some of the practical implications of dealing with food allergies and having people on staff that know how to deal with them, and whether or not that creates some liability issues for you. Here, just on the second slide, are some of the other states. We've got Virginia, Rhode Island, Massachusetts, and Texas talking about poster laws. Some of you are probably familiar with these. Getting food allergy posters out for staff or customers or for both. And so it looks like most of these are in place. Texas is still on its way. But at bottom, from a legislative perspective, things are trending in the direction of more requirements on food service establishments to be allergy sensitive, to have allergen training. And so these are important things to know. In terms of the takeaways from my presentation today, as far as how some of this stuff is going to practically impact you, our goals are, of course, to prevent an allergen incident from occurring and to be prepared to deal with an allergen issue if one arises. The first goal may seem obvious at first blush. Of course, you want to prevent an allergen incident from occurring. But in a legal context, it hasn't always been that clear. There is it's something of an old school mentality where some people would say, look, don't ask customers about food allergies. Don't have wait staff or servers ask them. Don't put any notices to inform us on the menus, because if they do tell us, then we have responsibilities to take care of them, and we don't want those responsibilities. And that is not a legal school of thought that I subscribe to. It's a defensive school of thought The idea there is, look, if we get sued, our ignorance, we could try and use ignorance as a defense. I would not recommend that to my clients. I prefer to be proactive or offensive. I think knowledge is power. The more that you know, the better positioned you're going to be to ever prevent an incident from happening. And if you can prevent an incident from happening, you don't have to worry about defending a lawsuit down the line. And so to me, the number one goal is preventing an incident from occurring. The ways we do that maybe aren't particularly surprising to you. It's having good policies and procedures, having good notice systems in place for your employees, but also for your customers, and of course, employing safe practices. And what we'll do, we're going to go through different ways that food allergy liability can manifest itself for you. And then we'll talk about how we take these steps, the policies and procedures, the notice, and the safe practices, and use those things to put yourself in as best a position you can be if a liability issue comes up. So here's a really quick background slide. A lot of you on the call are probably aware of this information, but number of persons diagnosed with food allergies increased exponentially in recent years. Approximately 15 million Americans and 6 million children have food allergies. And so what's happened as the prevalence of these individuals in our society has increased, people have found a business opportunity by literally catering to these individuals, marketing themselves as allergen-free or having allergen-free products. And it is an effective strategy. I know people in my personal life with food allergies. I'm sure that many, maybe all of you do as well. And we know how much stock those people put in knowing which restaurants are safe, for lack of a better word, for people with food allergies. And so there's a real business opportunity here if you can accommodate these folks. The issue with accommodating them, though, is that the stakes are high. As you can see in my next point, almost 200 people a year die from anaphylactic shock related to food allergies. Nearly 50,000 are hospitalized every year with complications. And so those are high stakes. And one question that we ought to be asking ourselves is, okay, if we're catering to these folks, what liability issues does that create for us given the stakes? So despite the increase in food allergen statutes like the ones we talked about at the beginning of this presentation, and despite the fact that statutory requirements are probably going to be greater and more encompassing in the coming years, the most common source of litigation for food service businesses is at common law. And in essence, think of that as somebody gets sick in your establishment because they have an allergic reaction and they sue you. In those cases, typically fall into one of two buckets. The first bucket is what we call negligence claims. Negligence claims, if you think of them, they're kind of reactionary claims. It's where a customer notifies you that they have a food allergy, and then you have a legal duty at that point to accommodate that allergy reasonably. They're reactive claims. The other bucket of claims are called strict liability claims, and these are proactive claims. It's when you know of the presence of a food allergy, of a food allergen in something that you're serving. Perhaps it's a latent allergen. And these come up in the context of a proactive duty to warn customers before they consume it. And so the common law claims break out into, most commonly, one or the other. What we'll do in the time we have here today is we'll walk through negligence, walk through strict liability, look at some case hypotheticals, and then talk about best practices and strategies to deal with what our legal requirements are. And so starting with negligence, let's put a little bit more flesh on the bones here. A negligence claim, negligence is the failure to take reasonable care to prevent an injury to somebody. So if an injury is reasonably foreseeable, a food service establishment like a restaurant or university would owe a duty of care to that person to provide them reasonable protections. In our case, of course, we're talking about an allergic reaction. The third point on this slide is important. It's critical. An employer is liable for its employees' actions. So that means that if any of your employees do something that's negligent, it could create liability for you. That isn't limited to waiters. It's not limited to cooks. It could be front of house. It could be servers. It could be bus people. It could be dishwashers. It can be anybody. We have a saying, and you'll see it throughout this presentation, if you know it, you own it. And that doesn't just mean if management level people know it. That means if anybody knows it. And so it's important to be aware of that. As we go through the negligence slides, remember these are the reactionary claims where a customer, a patron puts you on notice of an allergy condition. So I would ask you as we go through these, if you want to think of a hypothetical, I would ask you to think of a busy dinner service in a university setting. You've got students lined up like crazy, all clamoring for dinner. And on tonight's menu is pasta Alfredo. You can get it with chicken or you can get it with shrimp, okay? And so the first element of a negligence claim is notice. Like I say, these are reactionary claims where a customer has put you on notice of an allergy condition. Like I said, once you know it, you own it. You can see it there. And so if you follow our hypothetical, imagine that a student's walking through and he tells the server, look, I have a shellfish allergy. I need the pasta. I need the Alfredo with chicken. We know, based on Leslie University and other cases, at least in a university setting, that you can't just ignore these people. And so you have to reasonably accommodate them, and we'll talk about what it means to do that. But one thing that you want to do is once a server is informed that a patron has a shellfish allergy in this case, that's where their duty of reasonable care kicks in. And so that server has to know what to do and has to have had training on it so that when it comes time to actually do it, he or she can perform. This is a busy dinner service. Students are perhaps not the most understanding or accommodating patrons that you could have. And so it isn't always easy when the bullets are flying like that to stop what you're doing and take the steps that you've been trained on. And it's important that they have that training and that they understand what the stakes are in these kinds of cases. In a cafeteria setting like that, which we've described, the steps could include server immediately stopping, notifying the head of the kitchen that there's a shellfish allergy. Head of kitchen notifies the cooks and chefs that are working there. Perhaps one is designated to handle allergen dishes. If not, maybe they've all had training. Maybe there's a designated area to prepare allergen-free dishes. At a minimum, you get the allergen-free utensils, prepare that food immediately, get it trayed and plated in a way that's marked to the rest of the kitchen so that they know that that is a meal that's being served to somebody with a food allergy. They are extra vigilant to prevent cross-contact because they see the marking. And then somebody takes that dish right away and brings it back out to that student or that customer to further minimize the risk of cross-contact. We call that kind of the chain reaction in a negligence setting. Once somebody puts you on notice that they have a food allergy. And so, like I say at the bottom there, like we talked about in the last slide, once the information is conveyed to that server, the university knows it, and everybody in that setting is now obligated to have a reasonable reaction and make a reasonable accommodation for that student with the food allergy once they know it, they own it. So what is the duty of reasonable care? You're on notice. You know that you owe that student a duty of reasonable care. What does that mean really? And look, the law describes that as the degree of caution or concern that an ordinarily rational person would use to prevent injury, in this case exposure to a known allergen. That, like most things at the law, is more art than science. That's not perfectly clear, and so it's subject to different definitions in different settings. Like I say, if we go back to our Alfredo hypothetical, in some university settings, it may be reasonable to have an entire dining hall that's allergen-free. It may be reasonable to have an entire line that's allergen-free. It may be reasonable to have an entire table that's allergen-free. It may be reasonable to have a prep station that's entirely allergen-free. It depends on circumstances. Those are some of the ways to satisfy that duty. I am not saying that there's a legal obligation to do all of those. I'm not saying there's necessarily a legal obligation to do any of those, but courts are going to be looking at what's reasonable. Like it says there, you owe a duty to keep people safe while they're in your establishment. Like I said at the beginning, we want to prevent an incident from happening. And the most critical component is that staff training. It's the chain of command. It's the getting notice to the staff, and then each member knowing what they're supposed to do once they are notified of a food allergy, so that there aren't any mistakes. Because again, the liability stakes are high. You're talking about somebody that could certainly be hospitalized, could be hospitalized for days. You're talking about somebody that could be killed in your facility. And I can tell you that you do not want to find yourself in a position where you're at the defense table and you're in a courtroom and there's a jury looking at you and looking at a student's parents who died in your dining hall and trying to explain why it is somebody dropped the ball in the kitchen because they didn't know what to do, even though that student had disclosed a food allergy. You do not want to find yourself in that position. And so it's critical that staff is trained on what to do when they receive notice, who they're to inform, starting with, it could be the server. It could be starting with a busboy. Somebody pulls them aside in a restaurant setting and says, hey, I forgot to tell the waiter that I have a peanut allergy. That busboy has to know, boy, I better get to head of kitchen right now. I better find out which waiter is assigned to that table and get him back over there. Everybody needs to know what to do because the stakes are high. They need to know who to notify and then what to do when they receive notice themselves. I have a very quick slide on emergency devices, and I think what it comes down to with emergency devices, ladies and gentlemen, is if you have them in your facility and if you expect your staff to use them in an emergency situation, you better train them on how to do it. It doesn't have to be anything extensive or groundbreaking. The training can be pretty simple, but make sure you've given them some training on how to do it. You all may have heard of Good Samaritan laws. They exist in, as far as every state I'm aware of, they exist in. I can't speak for all of them, but the idea behind Good Samaritan laws is, look, we want to encourage people to render emergency aid if they see somebody in trouble. And the law is going to protect those kind of emergency responders, if you like, by saying, look, if you're trying to help somebody and they're inadvertently injured further, we're not going to hold you liable for that negligence. Okay? Now, Good Samaritan laws do not apply to what they call reckless conduct, which is something that's more egregious than ordinary negligence. And that's why it's important that if you have emergency devices on site that you expect your staff to use, any member of your staff, if you expect them to use it, you should train them on how to do it so that they're not deemed reckless. We talk about EpiPens, epinephrine, and defibrillators here on the slide. I do note at the bottom that portable defibrillators are often exceptions to Good Samaritan statutes. I know that's not necessarily allergen related, but it's just good information to have. You'd have to check your own state to see. So the negligence cases are those where a student or customer tells you, hey, I've got an allergy, and then you take steps to reasonably accommodate them. The next basket of cases, the next basket of claims that we're going to talk about are those strict liability claims, the proactive claims. And these are the ones that depend on your knowledge of latent allergens in the food that you're serving. These are strict liability claims typically arise in the context of products liability. If you think of a good food industry example, it's not allergen related, but it helps kind of bring it to life. You guys probably all remember, I know as a lawyer I do, the McDonald's hot coffee case. Woman orders a cup of coffee at the McDonald's drive-through. She spills some in her lap and is severely burned and sues McDonald's and collects a big damages award. And a lot of people look at that case and they think, boy, I can't believe it. Woman spills coffee and burns herself and gets paid for it. Who doesn't know coffee's hot? Well, the issue in that case was slightly more nuanced. What a lot of people don't know, what was going on there is McDonald's was serving their coffee significantly hotter than all the other restaurants. They thought it increased the flavor. They knew they were doing it. It was hotter than other coffees. But to look at it, you wouldn't know that. It just looks like a steaming cup of coffee. And so what the court said is, look, where you have a latent condition like that that could be more dangerous to the public, you have a duty to warn them about it. And they're not going to know just by looking at it. And so it's incumbent at that point on you, McDonald's, to take care of that. And that was kind of the basis for that damages award and all the rest of it. And so in a food if we take that principle and try and apply it into a food allergen setting, what I would ask you to do would be to consider two items that you might be serving to your customers. One is a peanut butter and jelly sandwich. We all know what that is. It has the word peanut in the name. And the other is a Buckeye candy. I'm here in Ohio. I'm a graduate of the Ohio State University. We're called the Buckeyes. So we all know what a Buckeye is. But regionally, other people may not know what that is. If you're on the call and you don't, it's a chocolate-covered peanut ball. But it doesn't have nut in the name. And at first blush, it could just look like a piece of chocolate to somebody. So think of those two items as we flip through some of these slides, and it should help bring to life where some of these strict liability failure to warn issues can arise. So again, as it gets applied to in the allergy setting, we're talking about failure to warn or the dangers of a food product. Prepared food has to be reasonably safe for its intended purpose, which obviously is consumption. In this duty to warn that we're talking about has been recognized in the context of the risk of harm to consumers with food allergies. So, okay, Ryan, we have a duty to warn. Well, when does it arise and how do we satisfy it? So your duty to warn arises when two elements are met. First is a substantial number of people are allergic to the ingredient. And then if that's the case, you go on to the second step, and the ingredient's presence in the product is not generally known to consumers. So if you think of our two peanut items that we're going to walk through here, are a substantial number of people allergic to peanuts? Yes. My advice would be yes. If a client were asking me that's one of the major 8, yes, a substantial number of people are allergic to it. So then we go on to the second element, is its presence in this product generally known to customers? And here's where you see some divergence. Everybody, at least in this country, knows what a peanut butter and jelly sandwich is. If you look at the sides of it, you can see peanut butter. Most significantly, it has peanut right in the name. So in that instance, you've got a good chance of having no duty to warn because that second element isn't satisfied. But compare that to the Buckeye candy. Peanut's not in the name, and as you look at it, it could just look like a piece of chocolate, So now you've got the allergen in it. It's latent. It's hidden, at least in a way that it's not generally known to the consumers. And there I think you probably do have a duty to warn. So you might be asking yourself, well, that's fine for peanuts, but how do we determine if a substantial number of people have a particular food allergy? And like I say, the law sometimes is more art than science. This is another example of that. There is no, there's not a set number or a set percentage of people that have to be allergic to something to make it a substantial number. As I say down there, if it's not reasonably foreseeable, a warning doesn't have to be given. So if you have some very obscure kind of one-off scenario, you probably don't have a duty to warn there. In terms of substantial numbers, I would be looking at the major 8, peanuts, tree nuts, fish, shellfish, eggs, milk, wheat, and soy. Best practice would probably be to include gluten there as well. Those are the kinds of items I would be looking at when I'm looking at substantial numbers of people. Okay, and the literature is pretty well out there on those items. So how do you satisfy the duty to warn? Think of the Buckeyes candy. Fine, I have a duty to warn. There's a latent allergen. A substantial number of people could have an allergic reaction. So what are you telling me I have to do, Ryan? And here are some of the things that you can do. The idea here, the theme here is to give clear warnings of the danger of an allergic reaction or the presence of an allergen in an item. So you see there's a notice there on the side. That's a general notice. Allergens could be here. So if you're in a university setting, that's something you could have right posted at the doorways going in. If you have menu boards or menus themselves or scrolling marquees, however it is you're communicating to your customers what it is you have available, you can provide a list of ingredients. If you don't want to do that, if that's too cumbersome, I would provide a list of allergens that are in the items that you're serving. You can do it with words. You can do it with icons. On menus I've seen a little shrimp for shellfish or a little peanut for nuts, something like that. Provide notice and disclosure on the menus or menu boards. Same kind of things that we're talking about. Providing employees with training to avoid misinforming consumers. So this is an important one because one way to satisfy your duty is, if you have a server or a waiter, if somebody orders a dish with an allergen in it, you can ask them, look, are you aware there's peanut? Let me tell you, there's peanuts in there. Do you have an allergy? Just so you know, there's shellfish. Are you allergic? Is anybody at your table allergic? Those kinds of things. And so it's important, if that's the way you're going to get the warning out there, that your staff is trained to do that. And the way to make sure that they have that training is to make sure that they're aware of changes in the menu. If you change your menu daily or weekly or monthly, seasonally, however you change it, the staff has to know what is in those dishes so that if they're asked or if somebody orders them, they can relay that information on to the customers. And here again, it may seem at first blush that, well, boy, that's training I should at least do with my waiters and waitresses. I would tell you that that's training that you should give to anybody that is going to come in contact with your customers or is going to come in contact with food. And that should be everybody. I mean, you can imagine a situation in a busy dinner service in a restaurant, like I said earlier, where a diner maybe has had a few cocktails and forgets to tell the waiter about an allergy and flags down a busboy. I have a father-in-law, God bless him, who if we're out to eat somewhere and he wants something, he's just going to flag down the nearest person in a uniform. He doesn't care if it's our waiter or waitress or not. They work there, so he's going to ask for it. And people like that exist. Take it from me, they exist. And it could be a busboy. It could be anybody walking through. And it's important that those staff members are able to answer questions about allergens, and at a minimum, if they can't answer it, doggone it, they have to let somebody know so that somebody can come out and address it, because those stakes are high. At the bottom there, once you satisfy your duty to warn, and this is an important point, the consumer also has a duty to exercise due care. And so if you've posted warnings and you've given warnings, they have an obligation to heed them, and that's the way, getting back to a courtroom setting, that you can defend these kind of lawsuits. Somebody says, hey, nobody told me there was peanut butter in the Buckeyes. Well, boy, here's a picture from the date of the incident with signage saying contains peanuts. Here's a warning as you enter the facility, peanuts in this facility. Here's a server with a documented history of training that says he or she warned them, and here's the training they've had over the last 3 years that shows that they understand when their obligation to warn arises. Those are the kind of things that a jury is going to listen to if you find yourself in front of one. And so it's important that you have those pieces in place before something happens. So I've got a couple of case illustrations that can kind of walk us through some of the negligence and some of the strict liability issues that we've been talking about here. And these are real cases. I pulled these off of real dockets because I was hoping that they would kind of bring it to life. But I think, I hope you'll see how these issues kind of play out in real world settings. So in the first illustration, a man with a history of asthma goes into a restaurant and asks the waiter if a soup contains MSG. Waiter misrepresents, probably not intentionally, maybe just didn't know, maybe was in a hurry, but misrepresents to the man that the soup does not contain MSG, when in fact it does. Man eats the soup, and, to nobody's surprise, has a reaction, MSG symptom complex. What's the first thing he does when he gets out of the hospital? He goes straight to his lawyer's office and files a lawsuit against the restaurant. Trial court dismisses the claim against the restaurant, but the appellate court reverses that decision, sends the case back down to the trial court with instructions to give that man a trial because of the MSG. Okay, so this is not a position you want to find yourself in. This is a problem. Every member of that jury has eaten in a restaurant at some point in their lives, and when they hear that the guy asked and was misinformed about the presence of MSG, that restaurant has a problem. They have a liability problem. That's going to be a tough day for them at trial. Here's case 2. Woman has a lifelong nut allergy, but orders the almond chicken from an Asian restaurant. She doesn't consult the menu before ordering and places the order over the phone. She doesn't ask the employee about ingredients, disclose her allergy, or make any other special requests. So it's not like the MSG case. This isn't a negligence issue because she hasn't disclosed her allergy. But she orders the almond chicken, doesn't say anything else. Eats the food and predictably goes into anaphylactic shock, 9 days in the hospital. What's the first thing she does when she gets out? Straight to the lawyer's office and files her lawsuit. In this case, the court grants judgment in favor of the restaurant, and that judgment is not reversed. Reasons being, presence of nuts was too generally well known to trigger the strict liability duty to warn, and the woman failed to inquire into the ingredients or give special instructions about her allergy, which might have triggered a negligence duty. So restaurant's in decent shape here. The one thing I would note for you, though, if you're listening to me in this webinar, is if there's one or two small factual changes in case illustration 2, I think you've got a problem. Imagine that was just called the spicy chicken or the sunshine chicken or firecracker chicken or whatever it would be. If it didn't have a nut in the name, what would be the obligation of that person who is just answering the phone taking to-go orders? What's their obligation to warn in that instance if you have one of the major 8 in there and it's not readily discernible by the name, and you have people ordering that potentially have not looked at a menu where you might otherwise have a disclaimer? Best practice would be to have anybody that could be in contact with customers, anybody that could be in contact with food, have the training and they know to ask. Because that case could have come out a lot differently if one or two facts were different. So the distinguishing factors, and we talked about these. One, you have a disclosed allergy, got a negligence duty, they breach it, the restaurant breaches it because they give misinformation and they're going to be on the hook. Asian phone order, no negligence duty because the allergy condition wasn't disclosed, no strict liability because there's nut in the name. I'm going to try and move this along so that we have time for questions at the end. The million-dollar question, of course, is how do I protect my business? And this is getting back to the things that we've talked about here. We talked about it at the beginning. We've talked about them kind of throughout, and here they are again at the end. It's the policies and procedures, it's notice, and it's safe practices. So in terms of policies and procedures, you want to have a procedure for determining customers' food allergies. Sometimes that's a notice in the menu. If you have an allergy, please notify your server. It can be your server or your waiter or waitress asking, is there anybody at the table with a food allergy? That kind of a thing. You want to have a procedure for when customers report a food allergy. It's the chain reaction that we talked about. Server, kitchen staff, special area, utensils, marked plate, marked tray, get it right out to the customer to eliminate as best you can cross-contact possibilities. Those kind of procedures, and you want to make sure there's training on that. You want to have policies for when allergens are used in a dish. Again, that's menu board disclosures. Buckeyes contains peanuts. It's menu disclosures. It's list of ingredients. It's those kinds of steps to get have a policy in place to get that information out to customers so they can inform themselves. It's also making sure your servers know what allergens are in dishes. So if they're asked orally about allergens in particular dishes, they can answer correctly and honestly. And it's having a policy for when a customer is having an allergic reaction. So, certainly you want your staff to dial 911 if somebody's in distress. If a customer tells you not to dial 911 or declines it, you can still call. It's your restaurant. You might be on the hook for the cost of that ambulance run, but that could be a best practice. If you're not going to do that and a customer declines emergency aid, you better document it because it could be a problem later on. I can tell you a very funny story I learned at a conference last fall at a Japanese restaurant where somebody was having an allergic reaction to nuts. It seemed to be clear that anaphylactic shock was on its way. The restaurant staff had training on the administration of epinephrine. Customer declined ambulance, was going to drive himself home, started to leave. Staff is coming after them with the EpiPen. Customer will not take it. Staff person actually throws it in the window of the customer's vehicle, and before they get out of the driveway, the car stops because, of course, that individual went into anaphylactic shock, and the passenger had to administer the epinephrine as a life-saving measure. So these things happen. You want to have a policy. That's an extreme example, obviously, but you do want to have a policy in place of 911, of emergency devices, if that's what you want to do. You want to have a policy in place that your staff knows and understands so they can follow it when the heat is on, when somebody's really having an allergic reaction. The next step is notice. Again, we're talking about notice to staff, kitchen posters, alerting them of allergens. That's a good way to do it. You want them to know when dishes change, what dishes have allergens in them, what don't. We're talking about notice to customers. Again, it's the menu notices, it's the menu board notices, it's notices at the entryway if you're in a facility that has allergens. It's servers asking, for example, and it's menu requests for your customers to notify you. Again, they have a duty to protect themselves as well. And so, you want to have a menu request or a board request of some kind so that they know to kind of be proactive and look out for themselves. And so the last element is safe practices. Like I say, it's training for all staff who may come in contact with a customer or with food. And I will tell you, AllerStar is a great program. Some of you may be familiar with it. They have very simple training materials that's easy to understand. It gets the points across. But the thing that I like the most about it is on the back, there's a spot for employees to print their name and sign that they received training. And it's important that you have records of training that was provided to people when it comes to litigation. If you're getting sued, a manager coming in and saying, yeah, we gave some trainings, I don't really remember when, but we've done it before, I know that. That isn't very strong testimony. Compare that to a stack of training materials where you can say, here's the training we did it on these dates. Here's the sign-in sheets where you can see everybody who undertook this training. Yeah, John Doe is saying he gave the warning, the customer is saying he didn't, but like I say, here's 2 years of training showing John Doe was trained to give those warnings. That's the kind of evidence that a jury is going to be interested in. And so it's important that you document that stuff as best you can. You want to have clear procedures to prevent cross-contact. That's kind of an obvious one. If you can have marked dishes, marked trays, marked utensils, those kinds of things. Cross-contact is something, even outside of an allergen setting, you wouldn't want in a kitchen. But with the stakes associated with serving customers with allergies, you really need to make sure you don't have it there. And then good sanitization and cleaning practices. Again, it's dedicated allergy-free utensils. We've all seen those purple utensils. If you don't have those, it's making sure that having dedicated utensils for preparing allergen-free dishes, making sure they're clean and sanitized properly, making sure they're stored properly, those kind of steps. And you want to have these practices in place and make sure that everybody knows what they are. Here's an important slide. But I have insurance, right? It says. Because you might be thinking to yourself, well, look, Ryan, this all sounds pretty scary, but look, even if the worst happens, at least I've got insurance protection, don't I? And I will tell you, the answer is maybe yes and maybe no. I think if you take one thing away from today's presentation, I would want you to go home and take a look at your insurance policy. Make sure that you have the coverage that you think you have. And if you don't, get on the horn with your agent and see what you can do about closing any potential gaps. I will tell you, the time to do that is not after you have been served with a lawsuit. At that point, that ship has sailed. And so you have to read very carefully what your policy language is. Because oftentimes, what we're talking about here are general premises liability policies. Somebody slips on a spilled drink in the dining room and falls and breaks their arm, okay? But when you apply those in different settings, like in an allergen setting, for example, there is potential for problems. It doesn't mean there are problems, but there is potential for problems. And I've got a few examples here on the slide. How is a bodily injury defined? Slip, fall, break your arm. That's a pretty clear bodily injury that occurred during that fall. Probably got coverage there. But what about an allergy condition? Is an allergy condition a pre-existing condition under your policy? And if it is, and if somebody has an allergic reaction in your facility, do you have coverage or is coverage excluded? You need to know that. How is occurrence defined? Again, if you think of the slip and fall in the dining room, Well, hey, somebody got hurt in your dining room. That's an occurrence in your restaurant. You've probably got coverage. But apply that in an allergy setting. What if somebody takes a step out of their restaurant and goes into anaphylactic shock there on the sidewalk? Or it happens when they go home? I can tell you they're still going to sue you. But does that fit in with your policy definition of occurrence? If that didn't occur until after they were out of the restaurant. What about intentional acts? You know, when we think of intentional acts, we think of somebody slipping poison into a cup of coffee or something like that. But that isn't the way it's always defined in insurance policies. Sometimes policies will define intentional acts as statutory or regulatory violations. Sometimes they'll define intentional acts as reckless conduct. And so you have to know, if you have an exclusion for intentional acts, what is and isn't excluded. The last one I have up there as an example is just contaminants, in a tainted meat setting, that's clear. But what about in a cross-contact setting? Is that a contaminant? And if it's a contaminant in what was supposed to be an allergen-free dish, do you have coverage or not? It's important to get to the bottom of that before an incident arises. So I also have here towards the end of the presentation some charts, and I'm going to skip through these quickly so that we have some time for questions. But look, this first one is a very basic kind of a to-do chart that summarizes some of the things we talked about already. This is not an exhaustive chart or an exhaustive list, but somebody notifies you of an allergy, execute the chain reaction, make records as best you can in case there is an issue down the line. What do you do if a customer has a reaction in your restaurant? You want to call an ambulance. Like I say, if they refuse, make note of it. Again, you want to document as much as you can, time, date, of course. Was the allergy disclosed? What did diner order? What did everybody order? How much did people have to drink? Are there receipts and other documentary evidence you can preserve? Get a list of potential witnesses. Try and get statements, surveillance footage if you have it. If you can preserve the food, that's great too. Do the best you can. Obviously, nothing's perfect in that regard. Conduct a team meeting. And then what to do when you get sued. You want to put your insurance carrier on notice right away. Gather your policies, speak with employees, compile information. It's kind of a lot of the stuff we've talked about. Get it to your lawyer, obviously. And this is just kind of for some levity. I borrowed these charts from a colleague, but to star client and a nightmare client, take a look at these. They're good for a laugh, kind of. And if you find yourself relating a little bit too much to the nightmare client, it might be time to think about if you need to make some policy or training changes that would put you in a better position to protect yourself if you had an incident occur. Here's my contact info. I will take some questions at the end. I know Lori has a few comments she wants to make before we turn it over for questions. But if we run out of time or your question isn't asked or answered, by all means contact me. I'm happy to try and help as best I can, or at least point you in the right direction. So with that, I appreciate your time, and I will hand it back over to Lori from here. Thank you, ladies and gentlemen.
Thank you very much, Ryan. To everyone on the call, we have been making note of your questions, and we will get to those in just a moment. But before we do, we wanted to share our next webinar topic with you. Coming your way April 25th is another important webinar entitled 10 Hot Topics in Nutrition. Join us to learn about food and health trends on the rise, special diets, and how your business can capitalize on these trends. This webinar will be led by our very own in-house nutritionist and master trainer, Julie Emanuelson. A registration link will be found in the email you receive after today's webinar, along with a survey that we would kindly ask you to fill out. Your feedback is valuable to us. And like every webinar in our 2017 educational series, this webinar today is approved for one Level 2 continuing education unit through the Academy of Nutrition and Dietetics. For those of you on the call who are interested in receiving those credits from A&D, The post-meeting email you receive will also contain a completed proof of attendance that you can simply download and submit to the Academy to redeem those hours. And lastly, I just want to remind everyone again that this webinar today has been recorded and it will be posted to the MenuTrinfo YouTube channel after we get done here today, and there will be a link to that posting in the email you receive later this afternoon.
Hi everyone, this is Leslie from the Allergen team, and I'd like to announce the 2017 Allergen Food Allergy Awards, which will recognize and honor those leading the charge in food allergy safety standards and training. So we need you to nominate your favorite restaurant brand, university food service, or individual that you feel is deserving of this special recognition for their dedication to the food allergy community. We'd like for you to nominate one deserving food service professional or entity in any of the 7 categories that are available to view at this web page, www.allertrain.com/2017awards. You can go to this website to see the awards categories and fill out the nomination form. And the nominations will be accepted until April 21st, and the winners will be announced at the NRA show on Sunday, May 21st at our MenuTrinfo Allergen booth, number 7264.
All right, so at this time we'd like to get some of your questions answered. We have a few minutes left. So the first question for you, Ryan, was in reference to the hypothetical situation you had mentioned at the beginning about the student with a shellfish allergy ordering chicken Alfredo. This question here says that shellfish and nut allergies are fatal, and that's absolutely true. Would it not be better to guide this person to a secure, allergy-friendly business and refuse service?
Well, a couple of points there. I will answer that question. Let me just say one thing about the posting of this presentation on YouTube. I'm not sure how long that will be up. I do want to remind people that this is for informational purposes only. Even this question and answer session, and this isn't legal advice and doesn't create a lawyer-client relationship. And while I'm happy to have the presentation up on the YouTube page, it is not. It's not for distribution beyond that. So I want to let people know that. Getting back to the question, though, the issue is this: what's your obligation to serve that student or that customer under the Americans with Disabilities Act, and this could also be a function of state or local regulation. You can't, if you have students there and you're requiring them to have a dining plan, for example, you can't then turn them away and say, we don't have anything for you, you have to dine somewhere else, but thanks for paying us. That isn't going to work. That's a little bit of the flavor of some of the issues that we saw in the Leslie University case. And so best practice, where we talk about a safe facility, look, if you have an allergen-free dining hall, of course, you would want to direct that student there. If you have an allergen-free line, you'd want to direct that student there. The issue becomes, if you don't have those things available, what are the reasonable steps you can take to accommodate that student, understanding that, look, he has this dining plan he had to have, and you're going to accommodate him. So that's where you get into the chain reaction that we talked about, going from server to kitchen, back to server, to make sure everybody knows what to do, having the policies and the utensils in place to accommodate that, because it's not always, at law, it is not always as easy as simply closing your doors to people and saying, look, you have allergies, we're not going to serve you. You can't always do that. And as food allergies become more prevalent in our society, you're not going to want to do that from a business perspective.
Great, thank you. And the next question is, can you be liable for wrong labeling of less common allergens such as corn and sesame?
Well, excuse me. mislabeling mislabeling can create some unique issues on its own. Labeling, when you're talking about packaged food for distribution, the laws can be more strict. They can be different than that which we've discussed here. If you're serving a food and you don't disclose it as having sesame, for example, and it does, and somebody, could somebody make a strict liability claim against you? I think that gets into the issue of, look, are a substantial number of people affected there by sesame allergy? And that's one that might be on the cusp. It's not a major 8, but it's a fairly well-known allergy. To me, best practice would be to disclose it and disclose it accurately. If you're doing something inaccurately, that's always going to create a problem for you. It's going to create more of a problem for you in the negligence setting, where somebody says, I have a sesame allergy, and you tell them, well, hey, here's an item that doesn't contain sesame, you're safe. They eat it and it contains it. That's like the MSG soup. You do not want to be in that position. So labeling is important. The laws that govern packaged food and packaged food labels do differ somewhat, or can be more encompassing than that which we've discussed today, kind of in the service industry.
Great. I think we just have time for one final question here. So the last
Sure.
question is, what are your thoughts about umbrella disclaimers that label all food as possibly containing any of the top 8 allergens? Is this avoiding reasonable accommodations?
In my mind, it is. That's a question potentially for a trier of fact. I'm not a big fan of umbrella disclaimers by themselves. If you have an umbrella disclaimer as you walk into a dining common, if you have one at the door that says, look, allergens, products containing them, allergens served here, something like that. If you have that as part of your policy, if you have that in conjunction with specific menu board disclosures, with servers proactively asking, if you have that in conjunction with, so notify your server of your specific allergy as soon as you can, that can be part of an overall strategy. I do not see that as a satisfactory policy standing alone. And look, I would ask you to think about what the 12 people in that jury box are going to think when they see that. And you're going to tell them that all they did to warn people about allergens was say, hey, anything in here might have an allergen, so beware. I don't know that you want to be in that position if you're defending your university or your restaurant, that's all you did and that you thought that was reasonable. I think you're going to have a problem there. If you use it as part of a larger strategy, I think it's a piece in the puzzle,
Right. Kind of the bare minimum there.
Yeah, maybe not even.
Uh-huh. All right. Well, that concludes today's webinar. We're just over time, so we want to be respectful of you, Ryan, and thank you again for your presentation.
Sure. Can I do one thing, Lori, just very quickly? I was going to put this up. Again, if you want to jot this down quickly, if you have questions for me that didn't get asked here, feel free to send them to me. I'll be happy to look at them. And if I can't help you, I'll at least try and get you pointed in the right direction. So thanks again for your time, everybody.
Excellent. Thank you all. Have a great day.
Bye-bye.